Good day, ladies and gentlemen. This is Dr. Frel, your professor. Hello class, good morning. Welcome to our course SSE 12, the Law-Related Studies. Our first topic for the course is the barangay justice system known as the Katarungang Pambarangay. The barangay justice system is a community-based dispute settlement mechanism that is administered by the basic political unit of the country, the barangay. So the system exists in order to help decongest the regular courts and works mostly as alternative community-based mechanism for dispute resolution of conflicts. And this is also described as a compulsory mediation process at the village level. Throughout the Philippines, the barangay justice system handles thousands of cases every year. So since officials have more flexibility in decision making, and they receive some resources from the government, so the courts are more numerous and accessible than other courts, and therefore the courts are able to hear more cases and to respond more immediately. So the establishment and operation of the barangay justice system is mandated under Republic Act Number 7160, or known as the Local Government Code of 1991. But prior to this law, however, the establishment of the barangay justice system had been covered by Presidential Decree 1508 in 1978 and Batas Pambansa bilang 337 or the 1983 Local Government Code. So the objectives of the creation of the barangay justice system first is to promote the speedy administration of justice, as I mentioned earlier, because it is more nearer to the people and it can settle amicably disputes among these people in the community. So it is expected that the administration of justice is much more easier and conflicts can easily settled. Second is to minimize the indiscriminate filing of cases in courts. Since there are conflicts that are mandated to be settled under the barangay level, so this will also minimize the filling up of cases in higher courts of law. And third is to minimize the congestion of court dockets, and out of that it will enhance the quality of justice dispensed by the courts, because the courts can now concentrate on cases which needs their immediate attention. And fourth is to perpetuate and recognize the time-honored tradition of amicably settling disputes at the community level. So, if you happen to witness how the barangay level settles disputes among claimants, then you will see that more or less the manner of settling disputes under this level is sort of an amicable settlement. So now, what are the strategies used under the system? So, looking into the barangay justice system, the main strategy for settling disputes is to provide a venue for the disputing parties to search for a solution that is mutually acceptable to them. So when we say disputing parties, we mean the complainants or the victim, and the second is the one being complained of. So, as they settle disputes, the punong barangay or the barangay captain and the lopon members, they do not act as judges or adjudicators of dispute, but they only serve as facilitators for the disputing parties' discussion of providing possible solution. So, in effect, uh, the settlement is amicable and the dissolution should be acceptable or mutually acceptable to both parties under the dispute. So in addition, the barangay justice system provides a friendly, inexpensive, and speedy forum for the settlement of disputes where the parties can freely explore options for amicably resolving their disputes without resorting to the courts. So given the reasons earlier, by settling their disputes at the barangay level, we can minimize the filling up of more cases in higher courts. However, this system provides, as mentioned earlier, for a friendly, inexpensive, and speedy settlement of their disputes. So under Section 399 of Republic Act 7160 providing for the creation of the lupong tagapamayapa or the barangay justice system, this provides that there is hereby created in its barangay a lupong tagapamayapa, hereafter referred to as the lupon, composed of the punong barangay as chairman and 10 or 20 members. The lupon shall be constituted every 3 years in the manner provided by the law. So remember class that the punong barangay or the barangay chairman will serve as the chair for the barangay justice system with 10 to 20 members. So, who are qualified to be lopon members? One is a person actually residing or working in the barangay. So, the qualification speaks for that that person should be a resident of the barangay or someone who is working in that barangay. Another qualification is those not otherwise expressly disqualified by law, as long as they are not disqualified by law. And another, those who are possessing integrity, impartiality, independence of mind, sense of fairness, and reputation for probity. So, this is another qualification where a member should possess, and that speaks for his being impartial or being fair in making judgment, or someone who have a reputation of probity, or someone who is always seeking what is true or right. Now, who are disqualified to be a member? One is those who are below 18 years of age. Another is those convicted of a crime, or those elected as government official, or member of the armed forces who is in the active service. So we have 4 disqualifications for this matter. So next is how they are being constituted. So under Section 399 of the Local Code, the manner of constituting or the procedure for the constitution of the barangay justice system was that within the first 15 days from the start of the term of the office as punong barangay, he or she shall issue a notice to constitute the lupon, which shall include the names of proposed members who have expressed their willingness to serve. Such notice shall be posted in 3 conspicuous places in the barangay continuously for a period of not less than 3 weeks. So meaning after the barangay chairman was sworn to office, within 15 days of the start of his term or her term, he shall issue a notice that will constitute the barangay justice system with the names of those persons who are qualified and are willing to serve as member. Next, within 10 days thereafter, so after the issue of the notice, the punong barangay shall appoint as members those whom he determines to be suitable therefor. Appointment shall be in writing, signed by the punong barangay and attested by the barangay secretary. So meaning after the issuance of the notice plus the posting of the notice in places where people can see it, now within 10 days thereafter, the punong barangay will now appoint members who he think are suitable to be part of the barangay justice system. And his appointment should be in writing, signed by him, and attested or witnessed by the barangay secretary. So in short, the appointment of the lupon is the sole prerogative of the punong barangay, and it does not require approval or confirmation of the barangay council. However, should the punong barangay fail to constitute the lupon, he or she can be charged for neglect of duty and be administratively liable. So let's make it clear that the appointment of the lupon is the prerogative of the barangay chairman. Even without confirmation, there's no need for a confirmation of the barangay council. And however, in cases where after the given a number of days, the barangay chairman failed to constitute or to appoint members of the lupon, that barangay chairman can be charged neglect of duty. Therefore, he will be held administratively liable to that neglect. So then, the list of those appointed members shall be posted in 3 conspicuous places in the barangay for the duration of their term of office. So the purpose of this is for the people to know or to be informed of the composition of the barangay justice system. So after their appointment, the newly appointed lupon members will immediately take their oath of office before the appointing officer or the punong barangay. That is provided under section 400 of the code. Now, how about the term of office of the barangay justice system members? It will be 3 years unless they are being terminated based on the following reasons. One is in case of death, another is in case of resignation or transfer of residence or place of work, or withdrawal of appointment by the punong barangay with the concurrence of the majority of all the members of the lupon. Okay, so once a member filed a resignation or once that member transfer his residence or his place of work, then his term of office is being terminated. Or if the barangay chair withdraws his appointment but with the concurrence of majority of all the members of the barangay justice system. Now, in cases where there is a vacancy in the lupon for any cause mentioned earlier, so the punong barangay shall immediately appoint a qualified person who shall hold office only for the unexpired portion of the term of the member who caused the vacancy. So in short, the one who will be replacing the post will only serve the unexpired portion, not the entire 3 years of 3 years of the term. Now, what are the functions of the barangay justice system under Section 402? One is for them to exercise administrative supervision over the conciliation panels provided herein. Next, to meet regularly once a month to provide a forum for exchange of ideas among its members and the public on matters relevant to amicable settlement of disputes, or to enable various conciliation panel members to share with one another their observations and experiences in effecting speedy resolution of disputes. So this means even if they do not have the conflicts to settle, members of the barangay justice system have to meet regularly once a month for them to have some forum or sharing of ideas if regarding any conciliation process or proceedings or experiences that that they think are effective in solving or for speedy resolution of disputes in the community level. Then aside from that, they can also exercise other powers and perform other duties and functions as may be prescribed by law or by ordinance of the barangay. Next is we have the secretary of the Lupon or the barangay justice system. So the barangay secretary shall concurrently serve as the secretary also of the Lupon. So he or she shall record the results of the mediation proceedings before the punong barangay and shall submit a report thereon to the proper city or the municipal courts. The secretary shall also receive and keep the records of proceedings submitted to him by the various conciliation panels. So, remember class that the barangay secretary will also serve as the secretary of the Lupon. And as secretary of the Lupon, she or he has a specific task to perform, particularly during mediation proceedings, and submit reports to appropriate authorities. Okay, then under Section 404 is the constitution of the pangkat ng tagapagkasundo. So, the law provides that there shall be constituted for each dispute brought before the Lupon a conciliation panel to be known as the pangkat ng tagapagkasundo, referred to under the law as the pangkat, which shall be consist of 3 members who shall be chosen by the parties to the dispute from the list of members of the Lupon. So, meaning class, out of the members of the Lupon, which are composed of 10 to 20 members appointed by the barangay chair, each dispute should be given by a pangkat ng tagapagkasundo whose members are also chosen by the parties under dispute. However, if the parties cannot decide as to who will compose the pangkat, then the number shall be determined by lots drawn by the chairman of the Lupon or the Lupon chair, who is also the barangay chairman. Okay. Now, the 3 members constituting the pangkat shall elect from among themselves their chairman and the secretary. So, the secretary of the pangkat will prepare the minutes of the pangkat proceedings and submit a copy duly attested to the chairman by the Lupon secretary and to the proper city or municipal court. So again class, Under the pangkat, the secretary might be different from the secretary of the lupon. Now, however, in cases where there are vacancies under the pangkat ng tagapagkasundo provided in Section 405, so any vacancy in the pangkat shall be chosen by the parties to the dispute from among other lupon members. Should the parties fail to agree on a common choice, the vacancy shall be filled by lot to be drawn by the lupon chairman. So again, class, in cases of vacancy, the parties in the dispute should choose among other lupon members. However, in cases where they failed to constitute they fail to agree on a common choice, so it is now the lupon chairman who will draw by lot the member who will fill such vacancy. Okay, now as to the character of their office, no? Under Section 406, the lupon members, while in the performance of their official duties or on the occasion thereof, shall be deemed as persons in authority as defined in the revised penal code. So, meaning, class, if the lupon members are performing their official duties or on the time or in the occasion that they are settling disputes, then they are deemed to be persons in authority. So, when we say person deemed in authority, it means that they have to be respected and their decision should be respected also by higher authorities. Decisions shall be respected by those parties in dispute. Next is their provision on their service incentives under Section 406. So, the lupon or the pangkat members shall serve without compensation, except as provided for in Section 393, where if the barangay has enough funds, honoraria may be given. So, meaning their incentives is subject to the condition if the barangay has enough funds. So, since it is clear that these members shall serve without compensation. So, while in the performance of their duties, the lupon or the pangkat members, whether in public or private employment, shall be deemed to be on official time and shall not suffer from any diminution in compensation or allowance from said employment by reason thereof. So, meaning, class, if during the mediation process or if they are settling disputes in this, lupon members or pangkat members are working or are employed whether in public or in private, they shall be deemed to be on official time. They should not suffer from any deduction in their compensation or in their allowances or in their time in their respective offices. Then another provision under service incentives is that under Shed Order number 62, providing for the guidelines implementing the steady grant program for barangay officials and their legitimate dependents, they are qualified for incentives or scholarship for their children. So, question is, who are qualified children under this provision of the law? So, those children who are not more than 21 years of age, those or high school graduate with an average of 80%, then they have to pass the entrance examination in a state college or university. and the income of the parents must not exceed 72,000 pesos annually. And as to your first activity class, make a data analysis of the number of cases in your barangay availing the Katarungang Pambarangay. And out of this data, prepare a term paper as to the advantages and disadvantages of settling cases in the Katarungang Pambarangay. So, you have 1 week to prepare for your first activity, and please submit your outputs in the Google Classroom. So that would be all, class, for the first topic under the course, and this is your professor saying thank you for watching and see you in the next video.